on one aspect of your question.
Are you saying sometimes vacature is the appropriate remedy?
If the absence of the dismissed defendant affected the outcome of the case or material
Portioning liability, things like that?
I mean, it could be with apportioning liability, but here there was no liability.
No, I understand that.
Yes.
So you're saying your rule is really case specific.
So as with any prejudice determination, it will depend on what actually happened in the case. My friends on the other side want you to think about prejudice sort of in the abstract with hypothetical parties, but you really have to look at whether there was prejudice to the parties in this case in these circumstances.
So there usually will be prejudice or often prejudice, but just not here.
There could be prejudice. I mean, I would depend on the circumstances, you know.
But then it's not really about jurisdiction, is it?
No,
I mean, if it's turning on prejudice, I mean, the court, normally we don't think of whether the court had jurisdiction or not as dependent on whether there's prejudice to a party.
Right, I'm talking, right, that's it. The question is, like, what is the remedy for the fact that you should have been able to have these two defendants together, right? The automatic remedy when you should have been able to sue two defendants together, one was improperly dismissed, and you didn't, is not automatically to vacate the judgment for the other defendant. You would only do that if the absence of the dismissed defendant affected the outcome, affected that judgment. But where it didn't, there's no reason to vacate that.
I mean, it is